SJC-12565, Commonwealth versus Antwan Gonsalves.
Great. Attorney Caddick.
May it please the court, Elizabeth Caddick for Antwan.
Hold on for 1 second. We've got an echo, and let's see if we can figure out why that is.
Seems to be a delay feed.
All set? Nope.
Oh, hear it.
Hello?
Okay, great. Thank you.
All
Okay,
right, may it please the court, Elizabeth Caddick for Antwan Gonsalves.
and we'll just start the clock. All right.
For any conviction based on extreme atrocity and cruelty, of course, the facts and the effect on the victim must be such that it was extremely atrocious and extremely cruel. The crime and the death of Tyrone Jones was certainly atrocious and cruel, but it was not extremely atrocious and cruel. It was not wicked, brutal, appalling, horrifying, and utterly revolting. It was a murder that was the equivalent of second-degree murder, but not a murder based on extreme behavior and suffering that justifies a life.
Counsel, I've been thinking about your argument, and one thing that I wanted to ask you was framing the argument as you do with regard to, okay, it's atrocious and cruel, but it's not extreme. Does that result in a desensitization, do you think? Is there a desensitization to this kind of conduct that's been going on in our case law?
No. First, the law on extreme atrocity and cruelty, as this court explained in Castillo, was because the legislature, back when any first-degree murder conviction resulted in death for the defendant, wanted to reserve any murder that resulted in execution to be either premeditated or extremely atrocious and cruel, and it certainly wasn't minimizing murder that was not extremely atrocious and cruel. But it's an element of the crime of first-degree murder, and therefore it has to be proved beyond a reasonable doubt in order for the conviction to be affirmed. And so the fact that that is the law, that it must be, utterly revolting, extremely atrocious and cruel, and in this case, it was a swift, maybe a 1, maybe a 2-minute fight that was senseless. There was no harboring of ill will between the two. There was no premeditation. The jury did not convict based on premeditation.
But there were 5 knife wounds, right?
Yes.
And any one of which, I think, or a few could have been fatal.
Right.
And the victim was conscious for a degree afterwards. So understanding that we might not be looking at looking at it from the victim's perspective, isn't this, if it's just anger and it's just a fight, isn't one knife stab enough?
Well, but this was what this court has found in so many other cases where it has actually, under 33E power, lowered the first-degree murder to second-degree. It's found relevant that this was just a spur-of-the-moment fight that was senseless among people who didn't even know each other, where alcohol was involved, and that was exactly this case. Mr. Gonsalves had been drinking all night. Even the Commonwealth's witnesses said that he had been drinking. He didn't want to drive later in the night because of his intoxication. And it was a swift stabbing. It looked as if he was punching the victim, and all of the witnesses said it was swift.
Well, now, can we go back to the idea of whether we focus on the conduct or the victim? If we had an unconscious victim already, and somebody engaged in extreme conduct, like say dismemberment or or something really egregious, gutting them or something like that to kill them, that would, if they were conscious, would that still be extremely atrocious and cruel, even though the victim didn't know?
Well, according to the law, where the jury had to find one of the Cunin factors, it's possible that someone could be convicted of extreme atrocity and cruelty, even if the victim didn't suffer, because that would have been one of the Cunin factors. So yes, and I suppose if society wanted retribution against someone whose behavior was...
Well, retribution or containment.
Exactly. But
I'd go with containment.
But this court has never said that any stabbing is extremely atrocious and cruel. And in...
This is a pre-Castillo case, right?
Yes, it was, but even...
So you're working with the cases before Castillo. Isn't this pretty much in the mainstream of those cases?
Well, Castillo was really a correction of what was initially not only the intent of the legislature back in 1854, but the interpretation of the legislature's intent in the Devlin case, which this court cited in Castillo, which was, I think, 1879, that discussed and kind of detailed what the extreme atrocity and cruelty would be. And even in Devlin, it said it always goes to the actions of the defendant and whether his actions were extremely atrocious and cruel.
We have multiple stab wounds. Did Castillo change our case law regarding multiple stab wounds?
No.
All right, what about your client's comment about poked, the brag? Does that show indifference, and does this, is that a Cunin factor?
Well, the law says indifferent to the victim's suffering, and so it's not as if the
Well,
defendant...
if he says, you know, in a boastful manner, I just poked him, doesn't it show he's not exactly feeling sorry for what he did?
First of all, we don't know that he said it in a boastful manner.
All right, then what manner do you think it was said?
And
And it's the light most favorable to the Commonwealth, correct?
right, but the fact that, you know, the evidence is to be viewed in the light most favorable to the Commonwealth.
All right, so-
If what you're arguing...
I'm not arguing, I'm
Which
asking.
I am. No, I'm sorry. If what someone is
You
arguing...
may think it's that, but I'm asking. Please tell me why we should discount or what weight we should put on the statement about poked.
Okay. The fact that it was a murder and someone would be sentenced to life, it would be with parole, but to life in prison for the murder, that would account for a comment like that. But the fact of extreme atrocity and cruelty is that the behavior has to be extremely atrocious and cruel, you know, brutal, wicked. This was
One of the Cunin factors is indifference to the suffering of the victim, correct?
I'm sorry, what was the beginning?
Yeah, I'm sorry.
I know.
Indifference to the suffering of the victim is one of the Cunin factors, correct?
Right, but it's, again, it has to be an extreme indifference, because if someone commits a murder, unless they immediately start sobbing.
Where does it say extreme difference? It's extreme atrocity, cruelty, I get that, of course. But in the Cunin lets out factors, but indifference is one of those factors.
Well, I think it would
I don't remember reading extreme indifference.
I think it would, but I think it goes without saying that it has to be, if what you have is something that goes, if you don't have premeditation, something that goes from second degree to first degree, because if you have someone who kills someone and just shrugs and walks off, they're indifferent, but there's nothing else to show that any of the Cunin factors, that is not first degree murder, unless you're only going to say second-degree murder is someone who is immediately remorseful and pleads for help for the victim. There still has to be something that makes this particular murder greater than a murder as a whole. And there is nothing, including, and again, the murder was atrocious and cruel, and there's certainly no intent to minimize
What about the notion of overkill? Right? We have, that exceeds that which is necessary to, you know what I'm talking about. Here we have independently fatal stab wounds. Isn't that, again, under Kineen, a factor, this overkill?
I would say no, because if the defendant had, for example, slit the throat of someone and then continued to stab them, but if someone is in the heat of a fight, is punching someone with a knife in their hands, and certainly
Well,
doesn't.
punching is a red herring, because any stab motion is going to appear to be a punch to someone who doesn't know someone has. So when you're saying punching, it kind of minimizes the fact that they're putting a blade into someone 5 times.
I understand, but what I'm getting to is that if what you're doing is acting in a frenzied manner, fighting with someone who angered you, and you don't have X-ray vision and know that you've hit a significant artery or vein or organ, it's.
But these are all in the chest and abdomen in fatal areas, right? In critical areas.
Yeah, there's certainly
It's
no.
it's not like some of the stab wounds were superficial, they were incised, they were, all that stuff. You have chest and abdomen 5 stab wounds.
Right. If someone was actually trying to kill someone and trying to go for a prominent artery, vein, or organ, and the victim is using defensive motions successfully, and in fact they're being stabbed perhaps 12 times, but nothing is being hit, that is, I think, worse. If they obviously eventually kill the person, than this type of situation where there's no evidence that the defendant was going for a vital organ, but still second-degree murder includes, an intent to kill, which, I don't even know was proved in this case, but it's still, so the fact that he may have intended to kill doesn't defeat the argument that he was not proved guilty beyond a reasonable doubt of extreme atrocity and cruelty. And the fact that.
I have a factual question. I'm reading from the motion for a new trial on page, it's in 77 in the record, but it's the defendant and Roscoe got back in the car. They were loud and happy.
Loud and.
Happy. That's Bethune testified that they were loud and happy according to the motion judge. Is that an accurate characterization of what Bethune testified to?
I don't remember her saying happy at all. I remember her saying she was trying not to hear what was going on or see what was going on.
But if she testifies they were happy, that's also another factor, right?
If they knew that they killed
Well,
someone,
if they knew
yeah.
that they stabbed him 5 times and they're happy about it, that's also a problem for you, right?
It could be. It was a small knife too. I certainly don't remember her saying happy, and I don't remember the Commonwealth, mentioning that in its.
Yeah, it's not in the Commonwealth's brief, but I
yeah.
just noticed that there's a cite to 216, page 82. Maybe the Commonwealth can look that up before they
Okay.
talk.
Okay. Well, I think that, again, if the court is going to say that any stabbing, clearly a stabbing that results in death is a stabbing that hit something vital. So that doesn't defeat the argument.
It didn't just hit one thing vital, it hit 5 things vital, right? It hit a whole bunch of different vital organs, right?
Right, although, a stabbing is the, second most common form of homicide in the United States, so it's certainly, and it's got to be something. And again, if the first, although the ME said that any of the stab wounds could have resulted in death, he was still alive after the 5 stab wounds. He fell. He asked for help. He fell. And he tried to get up and fell 2 more times. And then there's no evidence of him being conscious after that. And the exhibit that the Commonwealth admitted of the surveillance video from the 7-Eleven store shows that it doesn't show him moving at all. And when the paramedics got there, they started CPR and continued it as he was being brought away. So it looks as if he had no vital signs at that point. So I don't see that his suffering was extremely atrocious and cruel.
Attorney Caddick, let me just ask, is it fair to say that we only have to find that, the jury only has to find one of the factors, right? It's not a matter of weighing the whole situation, right?
Right. Right.
Because I understand there are some factors that do weigh in your favor, but
Right.
they found, the 5 stab wounds and.
I agree, but, for a review by this court is, of course, more familiar with murder as a whole than the jury, and the jurors have probably only known this murder, and so it is probably difficult for them.
Doesn't that go more towards our 33E review in those cases where we've talked about the people that come together and they don't know each other and they have a fight in a bar? Is
Right.
that what really you're talking about as in this argument?
Well, I certainly would,
No, I'm not asking you to concede
No,
anything,
no,
but this also goes to your 33E argument,
right, it
correct?
does, and there certainly was a 33E argument. And so that even if this court were to find all the elements of extreme atrocity and cruelty, there are cases where someone has a long history of terrible violence, and they certainly were
And
joyful.
can you help me, where does this case line up in those 33E reduction lines?
Okay, well, I had listed in the brief all the times this court had stated cases that had facts similar to this one. It was a senseless brawl among strangers where alcohol was involved. And certainly those were stabbings and stabbings as often as 5. I think one was 7. But also, even if you look at Castillo, where it lowered the conviction from first to second degree, and Castillo had gone to a party afterwards. I know the Commonwealth had characterized where Mr. Gonsalves went afterwards as going to an after party. There was no evidence that it was joyful or anything. It appeared to be somber from all the testimony. And in Castillo, he actually went back to the car to grab a gun and go and shoot the victim, and he fled the scene.
Isn't there
and-
some suggestion that he came back to the car to get the knife?
Well, the best evidence you have from 2 witnesses is that he went back to the car after he left. There's no legitimate evidence that he grabbed or retrieved something. I know the Commonwealth spent a lot of time in trying to justify the behavior of the defense attorney, who, of course, argued was ineffective, that she was able to get a not guilty on first-degree premeditated murder because of her skill, and claimed that there was evidence that Mr. Gonsalves retrieved something from the car. What Raskow said is that he went back to the car and didn't see him retrieve anything. And then this Arias witness specifically said, when asked the first of like 5 times by the Commonwealth, did he retrieve anything? I didn't see he retrieved anything, he just went back to the car. And then at some point, the DA said, when Arias was talking about something else, for 2 pages, said, and so he retrieved something from the car. Arias said yes, and then she said, so you saw him retrieve something, and then he didn't adopt that. He went on talking about what he had been talking about before. He clearly had English as a second language, and it was the words of the Commonwealth, not Arias, who specifically said he did not retrieve anything. So, and also, I just want to also point out that, it was presented in the record that the defense attorney had been suspended from the practice of law and was being disciplined for her neglect and malfeasance in cases involving criminal defendants. And the day after the brief was filed, this court affirmed her discipline and her suspension from the practice of law. So I asked the court to consider that when it looks at the ineffective assistance of counsel claims.
All set? Okay, thank you very much. Okay, Attorney Russell.
Thank you. Good morning, and may it please the court. Assistant District Attorney Lindsay Russell for Middlesex on behalf of the Commonwealth. Turning first to the sufficiency of the extreme atrocity and cruelty evidence here. Now, this is a murder in which the Commonwealth showed that the defendant, unprovoked, inflicted 5 separate, independently fatal stab wounds to the victim in his abdomen, where his vital organs are, before returning to his friends to boast about how he, quote, poked the victim up. Now, the medical examiner here testified about the severe internal injuries and bleeding to the victim, and there's both testimony and video footage, which I encourage this court to watch, showing the victim's conscious suffering as he stumbles around, holding his stomach, attempting to speak before collapsing onto the floor of a 7-Eleven. Now, these factors I would suggest represent at least 5 of the 7 independently sufficient Cunin factors, which your honors have touched upon with my sister. And just to go back to Justice Kafker's question about the loud and happy testimony, that actually came out from Trooper Murphy about what Bethune had had said to him during one of the previous interviews. So that didn't actually come out on her testimony, but that was unobjected to testimony that came out during Trooper Murphy's testimony. So I would suggest that that does go toward the indifference here that the defendant showed when he got back to the car and was explaining what had just happened. Now, as you know, as your honors pointed out, this case came before Castillo, which somewhat modified the Cunin factors. But even were we to look at this case through the lens of Castillo, I would suggest that the Commonwealth's evidence still easily suffices to show extreme atrocity and cruelty. Not only was the victim's conscious suffering shown, which, again, I highly encourage, and I actually filed a motion recently to transmit that specific exhibit that has that video evidence on there, and I would suggest that the court watch that to see, and it happens for, it's probably about a minute of him stumbling around and then falling onto the ground before his friends come over, and he's still moving around with blood coming, and he actually wasn't pronounced dead here until...
But doesn't Castillo warn us against that?
Well, I would suggest that, yes, Castillo, which again came out 3 years later, right?
No, but I understand Castillo, obviously, but Castillo interprets our common law, correct? So it warns us not to be overly swayed by the actions of, if someone hits a vital organ or doesn't, the person unfortunately suffers. Castillo told us to stay away from that, correct?
That's correct, that we can't divorce these factors from the defendant's conduct.
Right, when the focus is on the defendant's
Correct.
conduct.
And here, I think, other than the conscious suffering, we certainly have the excessive and disproportionate nature of the method in which the defendant, again, these 5 stab wounds, there's been cases where this court has found less stab wounds, and actually in Castillo, where this court found through its 33E review that it merited lowering that to a 2nd degree. In that case, there was only a single gunshot wound to the back of the head. And again, that was a situation where the victim was not blameless and had even possibly returned to his, or had at some point armed himself for a fight. It was a fight between individuals, whereas here we don't have any evidence to show that the victim here instigated any sort of violent or any sort of reasonable provocation from the defendant. It was the defendant and the defendant alone that instigated the violence and the hostilities here, and that's just not seen in Castillo or really any of these other cases where this court has found a reduction in either from first degree to
There's a
second.
larger argument between groups of people, though, correct?
I'm sorry?
I'm sorry. There's a larger argument between groups of people, correct?
Right. In some of these cases, yes. In some of them, it's still a one-on-one, but the victim is still actively
So
pursuing the defendant.
let me ask you, where does this case lie in 33E jurisprudence? And can you make sense of when we reduce cases and when we haven't in these kind of senseless fights?
Right. So again, I think Castillo is a good example where these two sides fighting against each other, and I think that's what the senselessness referred to there.
Because at bottom, most of these cases are senseless, correct?
Yes, certainly.
There are very few cases that make sense.
That's very true. I would suggest in Commonwealth v. King is another case it's from 1978, but that was another not a one-sided situation, and actually that was not extreme atrocity and cruelty, it was premeditation, but that was under 33E, that was reduced. Commonwealth v. Jones, 1975 case, that was from second degree down to manslaughter, where the victim had a straight razor on him, and the defendant said that he believed that the victim might stab him with a razor.
But we've had cases where people were in bars and they push into, the what are you looking at type situations, and someone ends up dead. And we've reduced them under 33E, correct?
We do. That's true, Your Honor. However, in this case, we don't have anything on the part of the victim showing that he instigated any sort of hostilities. All we have is that the victim walked up to the car, asked something about drugs, which obviously highly infuriated the defendant. And Rasco testified that he found it insulting, funny but insulting, whereas the defendant obviously took huge offense to this. And got out of his vehicle and not only confronted the victim once on the sidewalk to have some sort of verbal argument, but returned to his car, and there is evidence of this from two witnesses. Whether there's evidence there that he retrieved anything or not, he did return to the car at some point and go back to the sidewalk for a, quote, second altercation, and that is when these 5 stab wounds happened to the victim. There's no evidence that either that the victim was the instigator or even that the victim threw any punches or was involved in any sort of fight at all, like the cases you find where you have reduced based on 33E.
There's some undercurrent that this is 2 drug dealers. Do we need to buy into that, or how important is that?
I don't.
It's a fight over turf.
Right. I'm not sure how important the motive is here. It definitely explains something that would otherwise be completely nonsensical. However, as you know, we didn't need to prove motive. But I do think it kind of adds some color to the situation to see, but why exactly did this happen? Because there was evidence, at least, that there was some sort of discussion about drugs, and even the victim prior to the victim approaching the vehicle, the witness, Devin Queen, testified that he had asked the victim if he could get some weed from him because he thought that he smelled weed on the victim, and that is basically what brought the victim over to the defendant's car. For what reason, it's really not completely clear, but I don't think that's necessary here. And if there are no further questions on at least the extreme atrocity and cruelty, I'll just move briefly to what my sister mentioned about trial counsel being suspended subsequently to this. I would just, overall, as a response to that broad claim, really what the defendant is asking this court to do is indulge in dubious propensity evidence. What happened after this case to another client of counsel's in an appellate matter is wholly irrelevant to this case and whether this client was deprived of effective assistance with respect to his representation in trial. And I would just cite the McGuire case for that, 421 Mass 236. Counsel's performance here is clearly reflected in the record, and we don't need to go beyond that. It shows thorough preparation and familiarity with the issues, including extensive knowledge of the witnesses' pre-trial statements and how certain witnesses changed their testimony, omitted, or their narrative of what occurred, and omitted certain statements, and then later walked those back. And she used that in a highly effective manner, I would suggest, to impeach multiple witnesses on the stand.
Pasco has a long criminal record, and the trial judge doesn't get the record, right? So she's not aware. She makes a discovery request, but she never gets it, right?
Trial counsel, I don't think there's evidence to suggest that she did not receive the criminal records here. As you know, the Commonwealth is under an obligation to provide those as they would have been testifying witnesses, and I would suggest that I believe his entire criminal record would have been attached to the immunity order, although I do recognize that my sister says it was just that that charge for which he was on probation. But I would suggest that the fact that the file that my sister received from trial counsel didn't have all of the Commonwealth's discovery does not mean that trial counsel did not have all of Commonwealth's discovery at the time.
She doesn't use it. Isn't there some exchange at trial where it comes up and they ask whether she has the record and she says she doesn't? Or?
She says when the judge asks, she attempts to impeach. It's one of the victim's friends, I forget which one. She attempts to impeach him with a previous conviction. Prosecutor objects, and the judge asks if it's a certified conviction. And trial counsel says she doesn't have the certified conviction, so it doesn't allow it. But that's not with Rasco. But I would suggest that she thoroughly impeached Rasco with evidence directly related to this case and to his previous statements.
It's the problem are the pending cases that she doesn't get into, correct?
Well, he doesn't. I'm not sure he had any pending cases. With respect to Rasco, if you're referring to Bethune, she did have a pending case at the time.
Right. Maybe I'm sorry. I
Right, and that could possibly go toward bias.
Right.
However, in this case, it's unlikely. I would suggest that the trial judge would have even allowed that
the whole Curry favor
correct because,
argument, right?
Yes, right. Because she had consistent statements with her trial testimony prior to the uncharged incident. Prior to that occurring, she had already decided to cooperate with the Commonwealth. So, and in any event, even if the trial judge would have allowed trial counsel to cross Bethune on her pending charge, the Commonwealth at that point would have been able to admit prior consistent testimony, which would have just bolstered her damning testimony about,
But that's not admissible as of right, though, correct?
It's not admissible as of right. I'm just saying if the trial judge had allowed the bias evidence to come in about this pending charge, we would have been able to show that, well, she made statements that are consistent with her trial testimony prior to the incident that arose.
You could have asked to do that, not you could have, right?
Right. We would have. I would suggest that it might have been an abuse of discretion for the trial judge not to allow that, but correct, we would have requested, and I believe that we would have been allowed to do that in that circumstance.
One minor point. Was it error when Bethune says she spoke to God? There's no objection to that. I take it we don't want witnesses changing their testimony after they speak to God being brought up in court, right? Was that an error, and should that have been, or at least should that have been objected to?
No, I really don't see that as an error. I don't think that that's anything more than really just a witness saying that they consulted their conscience and decided to tell the truth.
A little different, isn't it?
I mean, I suppose
Speaking
she
to
did
God
say she
is-
spoke to God, right, after being locked up in jail for the night. But just to put that in context of the situation there, that was on cross-examination when counsel was asking, basically, why are you changing your mind all of a sudden on your narrative of what occurred here? And she says, when I came out from being locked up in a jail cell, I spoke with God and I decided I was going to tell the truth. So everything I said before that was a lie. So even if obviously I'm not
So
conceding
really,
that.
she was saying she spoke to God, not that God spoke to her.
That's true. She was saying she spoke to God. And I would suggest that she said it in the context of where she was also admitting that she had repeatedly lied to police. So I don't think that that goes much toward prejudice here, given the context in which she was admitting this. And, you know, this isn't anything, this was an innocuous, solitary reference. It wasn't repeated by the prosecutor in closing or anything, and it really just has, it's nothing like any of the cases in which this court has found trouble with the religiosity and prosecutors, you know, honing in on that with respect to certain witnesses.
Prosecutor doesn't bring that up in closing, does he?
She doesn't bring that up. She just says that, you know, when she took the grand jury oath is when she decided to tell the truth. And I would just, obviously, every day in this Commonwealth, witnesses swear to tell the whole truth, nothing but the truth, so help them God. And this really wasn't much different than that. And if there are any further questions on any of the other ineffective assistance claims or anything else, and if not, then the Commonwealth would rest on its brief.
Okay, thank you.
Thank you.